The morning my husband's attorney stood up in that courtroom and called me an unfit mother, I didn't flinch. I didn't cry. I didn't look at Marcus. I didn't grip the edge of the table or whisper to my attorney or do any of the things you do when something hits you somewhere real. I just sat there, still, and I waited. Because I had known this moment was coming for 11 months, and I had spent every one of those 11 months preparing for exactly what was about to happen next. My name is Renata Simone Caldwell. My name, the one I was born with, the one I kept through 16 years of marriage, and the one I walked out of that courtroom still carrying. I am 41 years old. I have 2 daughters, Amara, who is 14, and Jade, who is 9, and I want to tell you about the day a man who spent 16 years watching me raise his children tried to use those same children against me in a court of law. I also want to tell you what happened when his own attorney made a mistake that nobody in that room saw coming, nobody except me. But before I tell you about the courtroom, I need to tell you about the marriage, because what happened in that room on a Thursday morning in October didn't start there. It started much earlier, in a house in Lithonia, Georgia, on a Tuesday evening when my husband came home from a business trip and sat down at the kitchen table and said, very calmly, that he wanted a divorce. Marcus Caldwell was not a bad man when I married him. I want to say that clearly because this story is complicated enough without me pretending otherwise. He was focused and ambitious, and when he looked at you, he made you feel like the most considered person in the room. We met at a conference in Atlanta when I was 24. We dated for 2 years. We built a life in a brick house in Lithonia with a backyard big enough for the girls to run in and a neighborhood where everybody knew everybody's name. For the first several years, it was good. We were good together, the way 2 people can be genuinely good together when they're both moving in the same direction and neither one has started keeping score yet. The keeping score started when his career accelerated past mine. Not dramatically, not all at once, but I had stepped back from my position at the hospital when Amara was born. I was a registered nurse, 14 years on the floor, and I had never quite stepped back up to the same level. And Marcus, who had started in regional sales and built himself into a VP of operations by the time Jade was 3, began over the years to speak about my work the way people speak about hobbies. Nice, manageable, not quite serious. I noticed. I always notice. I just loved him enough to let it pass more times than I should have. The divorce conversation on that Tuesday evening was the first honest thing Marcus had said to me in about 2 years. He said he wasn't happy. He hadn't been happy for a long time. He said he thought we had grown into different people and that it wasn't anyone's fault. I sat across the table from him and I thought about Amara at 14, already so careful with her feelings, already so good at reading a room. I thought about Jade at 9, who still crawled into our bed on Saturday mornings and fell back asleep between us, like the world was entirely safe. I said, "What are you asking me to do?" He said he wanted a clean separation. He said he'd been talking to an attorney. He said he thought it was better for the girls if we handled this like adults. I said, "All right, I'll get my own attorney." I called my attorney the next morning. Her name was Denise O'Coffer, and she had been practicing family law in DeKalb County for 22 years. When I sat across from her desk and told her what Marcus had said, she listened without interrupting, and then she asked me one question. She said, "Has he given you any indication of what he's planning to ask for regarding the children?" I said he hadn't said anything specific yet. She nodded and wrote something down and said, "Then we need to be ready for everything." I didn't fully understand what she meant until 3 months later when Marcus's attorney filed the custody motion. Full physical custody, sole decision-making authority, a petition that described me, Renata Simone Caldwell, 14-year registered nurse, the woman who had attended every school conference and every pediatric appointment and every midnight fever for 9 and 14 years, as a mother whose instability made her unfit to have primary custody of her own children. I read that filing at Denise's office on a Wednesday afternoon, and I sat with it for a long moment. And then I said, "What do we do?" Denise set the folder down and folded her hands on the desk and looked at me with the specific steadiness of a woman who has sat across from a lot of people in the worst moments of their lives. She said, "We document everything. Everything you have done and everything you continue to do. Every appointment, every school pickup, every medical decision, every conversation. We build a record so complete that the picture it paints is impossible to argue with." I went home that evening and I started a notebook. Not on my phone, a physical notebook, the kind you buy at the drugstore, with a pen clipped to the cover. I dated the first page and I wrote down everything I had done that day for my daughters. The school pickup, the dinner, the homework, the conversation with Amara about a situation with a friend that had been bothering her for a week, the 20 minutes I had spent with Jade on her reading before bed. I wrote it down. Every day for 8 months, I wrote it down. Every appointment, every permission slip signed, every school email answered, every teacher conference attended, every Saturday morning at the kitchen table with both girls while Marcus was wherever Marcus was. Denise had told me to document. What she hadn't told me, what I discovered on my own, was that Marcus's attorney was going to do the same thing. That everything Marcus's side of the table submitted into evidence was going to be handled, organized, and filed by their team, and that sometimes in that process, people file things without reading them closely enough. That was the mistake. The custody hearing was scheduled for a Thursday in October. By that point, Marcus and I had been in mediation twice, both times without resolution. He wanted primary custody. I wanted joint physical custody with equal decision-making authority. Neither of us was willing to move. The night before the hearing, I sat at the kitchen table after the girls were asleep, and I read through every piece of documentation Denise had prepared. Our evidence was thorough, 467 pages of records, organized by date, covering 8 months of daily life. Doctor visits, school records, extracurricular schedules, communications with teachers, pharmacy receipts, everything. I also read through the exhibits Marcus's attorney had filed, all of them, not because Denise hadn't already reviewed them, she had, but because I needed to understand the shape of what we were walking into. I read until 1 in the morning, and somewhere around page 212 of their submitted exhibits, I found it. It wasn't dramatic. It wasn't a smoking gun in the way people imagine those things. It was a series of emails, communication logs between Marcus and the school, submitted by his own attorney as evidence of his active involvement in the girls' education. Except the emails weren't from Marcus. They were forwarded by Marcus. The original sender on every single one showed my address, not his. His attorney had submitted my emails, the ones I had sent to the school over 3 years, the ones Marcus had forwarded to his own account at some point, as evidence of Marcus's communication with the school. They had not read the header information carefully enough. They had not noticed that the original sender field on every forwarded email showed my address, not his. I called Denise at 1:15 in the morning. She answered on the second ring. I told her what I had found. There was a pause on the other end of the line. the specific quality of pause that comes from a very experienced attorney realizing something important. She said, "Don't change anything. Don't touch any documents. I'll see you at 7:30 tomorrow morning before we go in." I didn't sleep much that night. I lay in the dark and I listened to Jade breathing in the room down the hall, and I thought about everything that had led to this moment. 16 years of a marriage, 8 months of documentation, one Tuesday evening at a kitchen table, and now a Thursday morning in a courtroom where someone was going to stand up and try to tell a judge that I was not who I knew myself to be. I thought about what Amara had said to me the week before, sitting at the counter while I made dinner. She had said, very quietly, the way she said important things, "Mom, whatever happens, you're still the one who shows up." I had not cried then, and I did not cry now, but I had held on to that sentence the way you hold on to something you need to keep close. The courtroom was smaller than I expected. Wood paneling, fluorescent lights, the particular stillness of a room where difficult things happen routinely. Marcus sat at his table with his attorney, a man named Gerald Pierce who had a reputation in family law sepals for being aggressive. He had not looked at me when I came in. He had looked at his phone. Denise and I sat at our table. She had the full exhibit packet in front of her, tabbed and organized with the precision of a woman who had been doing this for 22 years and had never once gone into a courtroom unprepared. Gerald Pierce gave his opening statement. He described a mother who was emotionally unavailable, who prioritized her work schedule over her children's needs, who had, in his words, abdicated the daily responsibilities of primary parenting to focus on her career. He said the evidence would show that Marcus Caldwell had been the consistent, present, involved parent throughout the marriage, and that the children's best interests required them to be in his primary care. I listened to all of it, still, without expression. Denise gave our opening statement. 14 years of nursing, every school record, every medical appointment, the notebook, 467 pages of daily documentation. She laid it out methodically and without drama. Then the evidence phase began. Gerald Pierce called his first witness, a character witness, a colleague of Marcus's who spoke about what a dedicated father he was. Denise cross-examined briefly, established that the witness had never been to their home and had no direct knowledge of the children's daily lives, and sat down. Then Pierce began presenting his documentary evidence, the logs, the school emails. Denise let him present them. She sat quietly, her hands folded, watching. When Pierce finished his presentation of the email exhibit, the judge reviewed it briefly and asked if the defense had any questions about this particular exhibit. Denise stood up. She said, "Your Honor, I'd like to draw the court's attention to the header information on the emails in Plaintiff's Exhibit 14C. She walked to the screen where the emails had been projected, and she pointed to the header field. The "from" field on each of these emails shows the original sender as Renata Caldwell. These are forwarded emails. The original communications were sent by my client, not by the plaintiff. Gerald Pierce was on his feet immediately. He said there must be a misunderstanding. He said the emails showed Marcus's active involvement. He said, the judge raised a hand. Pierce stopped. The judge looked at the exhibit. He looked at it for a long time. The courtroom was completely quiet. He said, "Counsel, are you representing to this court that these emails were sent by your client?" Pierce looked at the screen, and I watched something happen on his face that I had seen before, the specific expression of a man who has just understood something he cannot unsee. He said, "Your Honor, it appears there may have been an error in how this exhibit was compiled." The judge set the papers down. He said, "It appears so." What happened next took about 40 minutes. The judge requested a brief recess. Denise requested that the email exhibit be formally stricken from the record as misrepresented evidence. Pierce did not object. The recess lasted 22 minutes. When we came back, the judge had reviewed our documentation, and Pierce had conferred with Marcus at the table in a conversation that I could not hear, but could read entirely from the set of Marcus's shoulders. When court resumed, the judge addressed both parties directly. He said he had reviewed the submitted documentation from both sides. He said the record before him showed clearly and comprehensively who had been the primary caregiver throughout the children's lives. He said the court's obligation was to the best interests of the children, and that the best interests of the children were served by stability, consistency, and the continuation of the parenting relationship that the evidence demonstrated had existed throughout their lives. He awarded primary physical custody to me, joint legal custody, equal decision-making authority, and a structured visitation schedule for Marcus. I did not react. I sat completely still while Denise made notes and the clerk recorded the ruling. I looked straight ahead at the wood paneling on the wall. Marcus did not look at me when it was over. He and Pierce gathered their papers and walked out quickly, the way people walk when they need to be somewhere else before the feeling catches up with them. Denise put her hand on my arm briefly. She said, "You did that. 8 months of notebooks. That's what won today." I said, "The girls did that. I just wrote it down." I called my mother from the parking garage. She answered on the first ring the way she always does, like she has been waiting, like somewhere in her she always knows when something important has happened. I told her the judge had ruled. She was quiet for a moment, and then she said, "I knew, baby. I knew from the day you started that notebook." I drove home. The girls were at school. The house was quiet. I sat at the kitchen table, the same table where Marcus had told me he wanted a divorce 11 months earlier, and I put my hands flat on the surface, and I just sat there for a while. Not in triumph, not in relief exactly, something quieter than both. Something that felt like the particular stillness that comes after a very long time of holding your breath. Amara found out when she got home from school that afternoon. I told her carefully in the language you use with a 14-year-old who is old enough to understand most of it and young enough to still need you to hold some of it for her. She listened, and then she said, "So we're staying?" I said, "You're staying." She nodded, and then she went to her room to do her homework, the way she does every afternoon, with the particular steadiness of a girl who has learned, from somewhere, to keep going even when things are hard. Jade found out at dinner. She asked fewer questions. She ate her food, and then she looked at me across the table and she said, "Dad's still going to see us, right?" I said, "Yes, Dad loves you. That part doesn't change." She nodded and went back to her dinner. I have thought about that Thursday many times since. About the emails that Marcus's attorney submitted without reading them carefully enough. About the 467 pages of a notebook that began on a Wednesday evening 11 months earlier because a woman told me to document everything. About the way evidence works, not just in courtrooms, but in lives. The way the record of what you actually do, accumulated quietly over time, eventually becomes impossible to argue with. Marcus and I have found a way to co-parent that is not warm, but is functional. He sees the girls on the schedule the court set, and he has been consistent with it, which is what matters. Amara is 15 now. Jade is 10. They are doing well. They are doing, I think, exactly as well as two girls can do when the people who love them are honest enough to put the children's stability above the debris of their own disappointment. The notebook is still on my kitchen counter. I don't write in it every day anymore, but I keep it there because I am a woman who has learned what it means to have a record of your own life, to have proof, documented and dated, of who you actually are and what you actually do. I want to say something to anyone listening who is in a situation where someone is trying to tell a story about you that isn't true, where someone with more resources or more confidence or a louder voice is constructing a version of you that you don't recognize. Document. Not to be combative, not to build a weapon, but because the truth, written down and dated, becomes something that cannot be taken from you. The record of who you are and what you do, consistently, quietly, day after day when no one is watching. That record is the most powerful thing you own. Renata Caldwell sat in a courtroom on a Thursday morning while someone called her an unfit mother, and she let the notebook answer. If this story moved you, share it with someone who needs to hear it today. Subscribe to Zuri Chronicles, because every week we come back here and tell another story, another truth, another woman who let the record speak for itself. My name is Zuri, and I'll see you next time.